Good afternoon, everyone.
Good afternoon.
Welcome to our session, The Challenge of Balancing Privacy and Security in a Rapidly Changing World, or the alternative names, Boiling the Ocean, or the most difficult panel of the day. So with that, I'm Randy Sabett. I'm special counsel at Cooley. I'm in our cyber data and privacy practice group. What we're going to do today, first of all, we have an amazing panel here. I actually think this is the best panel of the day. I'm a little biased there. But to my left is Judith Germano, who's a distinguished fellow at the NYU Center for Cybersecurity and an adjunct professor of law there, also the founder of GermanoLawLLC. To her left is Alex Joel, who's the Chief Office of Civil Liberties, Privacy, and Transparency in the U.S. Office of the Director of National Intelligence, ODNI. Third down is Michel Servoz, Senior Advisor to the President of the European Commission on Robotics, Artificial Intelligence, and Future of European Law as part of the European Commission, and the best title or best credential or name of a position, I think, of anyone in terms of the whole AI piece there and the robotics. Love that. And then next is Joel Wallenstrom, who's the CEO of Wickr. And at the end is Eija Warma-Lehtinen, who's a partner and the head of the data and privacy protection practice at Castrén Snellman. So I know everyone's bio is in the book. I just want to give you a quick overview of who's on the panel. I think you're in for a real treat. When we had some of our prep calls and emails, I actually wish we had a recorder running because, and in our prep session in the other room, because we've gone through some really interesting topics. We won't have time for them all today. But I first want to lay out a couple of ground rules. What I'm going to do is I'm going to start off with a couple of comments, and then I'm going to ask each of the panelists to give a little bit more about their background that may not be in the book that may be relevant to the discussion, and then more importantly, give you 2, 3, 4 minutes, 5 minutes about their take on this topic, where they come from, how they come to it. Obviously, it's a very polar topic, or we wouldn't be talking about it, and so I think it'll help to understand where they're coming from and set the stage for the discussion to follow. We don't have a PowerPoint, so we hope for lots of questions. I like things to be interactive. We had talked about different formats, maybe ask a question, go down the panel. I'm going to ask folks to jump in, interrupt, have it be a real discussion, and if folks want to jump in, please feel free. Which reminds me, I have a couple of other administrative issues here. For those in the overflow room, because we have an overflow room that we're streaming to, we have a mic here that we've moved somewhere toward the back that you can use if you have a question. This session is on the record, so recognize that in giving your responses or asking your questions. Please silence your phones, and a bunch of other stuff that you've already heard. Blah, 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 blah. Okay, and then we end at 2. The next session will be back in Lister Auditorium with Chris Krebs starting at 2:30. Okay.
I had to say that was reminiscent of how people read privacy policies.
Wow. All right, so I'll do this. How many folks still read every privacy policy they run into? I used to be able to raise my hand, but I've gotten to the point where even I don't read them. But it is something that I think is important and people need to recognize. But that does bring up actually a good point in terms of how we're going to go through this. I think one of the things to recognize is that we've been talking about this topic for years. All right? So my background, I'm a former crypto engineer from the NSA and became an attorney years later. So my joke is I went from one dark side working at the NSA, went to a darker side, became an attorney years later. But it's been a really interesting path in terms of the issues that I've run into both in privacy and security. It's also, as an attorney, I guess you'll support me on this maybe, most attorneys view things somewhat cynically because of the stuff we see. I tend to be even more cynical because of that background. So 11 years ago, I was on the Commission for Cybersecurity. We were talking about all these same issues. 16 years ago, we had the National Strategy for Cyberspace, talking about all these same issues. Go back 55 years, there was a RAND paper by a guy named Paul Barron. It's one of my favorite papers on these kinds of topics. A little bit more on the security side, but he basically talked about we have to raise the price of the spy information such that the attacker, it makes it impossible for the attacker to go there because the attacker is going to be attracted somewhere else. or as I like to say, it's the, I don't need to be faster than the bear, I just need to be faster than my buddy kind of thing, right? Let him attack my buddy, or let him attack the other property on the internet or whatever. But I think the takeaway is, we're talking about a balance here. We haven't yet struck it. In fact, it seems to be constantly going back and forth. I would actually say today, to some extent, I think folks are looking at the pendulum perhaps swinging, more in favor of privacy. I think for good reason. Here in the U.S., because of certain national security interess or supposed national security interess, because of the open e-commerce environment that we wanted to foster, privacy hasn't necessarily been a priority. I won't say people have ignored it, and a lot of folks out there, have definitely looked at things. Alex will talk in a little while about some of the things he's doing and some of the things others are doing as well. But I think, when we look at the U.S. and when we look at other jurisdictions, at least here, we don't necessarily view privacy as a fundamental right, which other jurisdictions do. But the question then becomes, where does that balance get struck? How far do we go where security or law enforcement can't do the things that they necessarily need to do, where things are made much more difficult? How do we strike that balance? And when we were talking earlier, there's really three stakeholders, I think, at a broad level. You've got national security, in whichever jurisdiction we're talking about. You've got the citizens, but then you've got the corporate side of things. So between those three, it complicates it even more in terms of striking that balance. Now we have GDPR, we have CCPA. Some folks have said if CCPA gets picked up, throughout the U.S., we run into a situation where the e-commerce model breaks. And all the stuff that consumers used to think they get for free now realize that their personal information was the currency. And now they have to turn over real currency. So how's that going to change things? So those are all the issues that I think set the stage here. With that as background, what I'd like to do now is, as I said, go through, have each of the panelists talk a little bit about where they come from at this issue, and then where they may see things going. So, Judy?
Thank you, Randy. So, I've come to the topic of privacy and security as a former government person, as a current advisor to companies, and also as an academic. And with all of those, there's still a lot more questions than answers, often, unfortunately. Traditionally, there were folks who did security and there were folks who did privacy. And one of the big problems we have is that those are still very much siloed in organizations and in how we think about it. And some of the work I do in working with companies is to make sure that the privacy and the security people are speaking to each other and speaking the same language. And then also adding to that is the fundamental question of what even do we mean by privacy. We say that we care about privacy because it would be very unpopular to say we don't. But on the other hand, companies are thinking about the marketability of the information, the ability to monitor their employees, how much is appropriate. And I find a good way to consider privacy is think of a creepiness spectrum. And where on the creepiness spectrum are you comfortable being for your corporate philosophy or your agency's philosophy or your organization's philosophy? So in terms of how you consider privacy and what you take, but then also realizing that if you're collecting information, what are you doing to ensure that you're protecting it? Or what disclosures are you doing to make sure that you are properly making sure people know so that you don't have the later minute of getting called to Congress to say, oh yeah, we did sell all that information we were gathering. It's all about, I think in terms of understanding privacy, is the terms are more about control and choice and disclosure to figure out how we wrap our heads around this. And then we get into the regulatory framework and obligations and laws that implicate what you can and cannot do with privacy and how you have to protect it. So I think those are some of the big issues that I've dealt with in my academic research and teaching at NYU, and then also in the work that I do advising companies. Previously, when I worked for government as a federal prosecutor, well, give us all your information, you can trust us, we're responsible, I have a proper purpose and a subpoena, and we're protecting it. But now working with companies and realizing it's not only about how they work with the government and what they do, but how that is perceived by their customers and by their clients. And there's a lot of hurdles in terms of trust and benefits and the spin on what comes out of how you're seen as either a government or as a company how you seem to care about privacy, this word that we don't really understand how to define it anyway. But if you have people's personal information, you have to protect it, which goes back to making sure the right people are thinking about the issues and talking to each other. And that's a lot of what I get to do in my job.
So in terms of the creepiness spectrum, who determines creepiness? Because I think that's, we're talking about a balance here of things that are, there's not a bright line. Here's creepy, here's not.
And I think that is, it depends on the company, it depends on the purpose, it depends on the information. If you are a company handling highly sensitive information, your employees who have higher levels of access understand that they may be giving up additional privacy and subject to greater monitoring than other employees. And so that's why it's a spectrum as opposed to baskets, because it does vary. But a lot of it, I think, also depends on what the company says. So there are companies who say, we care about your information, we protect your information, we're not using it in certain ways, and we're not selling it. I say, have you talked to digital marketing? Because they just signed a contract. So again, it's making sure that the companies are setting themselves out in an accurate and appropriate way based on the information. But where they are on the creepiness spectrum may depend on the company's own philosophy, just like a company has to determine its appetite for risk on cybersecurity. You only have so many resources that you can put toward security, but you need to prioritize and make sure you're doing it in the right way. Similarly, how are you going to consider, maybe you collect less because it doesn't, you're not comfortable being on the front page of the paper explaining that you were taking more than you needed. But companies have to start thinking about it, which I don't think is happening enough yet.
Alex?
Introductory remarks?
Sure. So thanks a lot for moderating this, Randy, and I appreciate the opportunity to come here and talk to you guys. I am the Chief of the Office of Civil Liberties, Privacy, and Transparency for the Director of National Intelligence. For those of you, I see several familiar faces and a lot of experts in the room, but for those of you who don't follow Washington bureaucracy as carefully as others, the Office of the Director of National Intelligence is the office that was created after 9/11 to better coordinate the activities of all the other intelligence agencies in the United States government. So we work with NSA, CIA, FBI, and all the other intelligence community elements. There are 17 total. The Office of the Director of National Intelligence itself has several centers that are relevant here. They have the National Counterterrorism Center is housed in my organization, as well as the National Counterintelligence and Security Center, NCSC, as well as the Cyber Threat Intelligence Integration Center that we refer to as CTIC. And these centers are designed to try to bring together information from around the federal government to better enable analysts to identify intelligence that policymakers need to carry out their jobs. So it's an organization that really is epitomizes what we're trying to achieve in the intelligence community, which is an integrated picture of what's going on that in terms of national security threats that our policymakers need to know to give them a decision advantage over adversaries. My job is in the statute that created the Office of the Director of National Intelligence. The job is formally titled the Civil Liberties Protection Officer. I've held that job since stand-up of the ODNI, basically going back to 2005. So I've been in that same job for 14 years. The job has changed, the world has changed, but I'm still in that same position. So I don't know what that says. One of the most recent changes to the job that I'm in is that we added transparency. So for most of the time that I've been in this position, we've been focused on how do we both protect national security and protect privacy. How do we share information but maintain confidentiality? How do we provide for safety but at the same time make sure that we preserve freedom? How do we guard against threats without ourselves becoming a threat, right, as the government? The government is, of course, perceived as a threat by civil libertarians, and we have to be very careful with how we carry out our activities because we do not want to run afoul of the Constitution and the laws of the land. So more recently, transparency has been added to the job jar for not only me but the entire intelligence community. And there we have a different paradox. I mean, some of this is just a series of paradoxes, right? So how can you do both of these things, seemingly contradictory statement that is nonetheless true, is a paradox. And the more recent one is we have to keep secrets, but we have to be transparent at the same time. So how do you do both? And sometimes I think of the job and everything we're talking about here as polarity management. You were talking earlier in one of our sessions about the bipolar aspect of the discussion. And when you think of a balance, it's also this weighing of interest that one counterbalances the other. And I've always thought of that, by the way, in terms of metaphors, as it's our job to maintain the balance. So it's not Lady Justice holding the scales and seeing which side outweighs the other. It's us making sure that scale remains balanced. You can think of it in different ways. I've thought of it as a tightrope walker. You want to stay on that rope. You don't want to go over one way or the other. Too much on one side, too much on the other, and you're off the rope. But that's too scary an image, and it seems like it's too finely tuned in calculation. So I haven't really used that one in my talks. Lately, I've been thinking of it as sort of a gyroscope, right? You're constantly adjusting. So you can't. You're never going to be static. And one of the things that I think we have to get comfortable with is you have these different things that are in some ways in opposition to each other. You're never going to, I don't think, find one sweet spot that you're going to be in for the rest of the decade or for the rest of the, even the next couple of years, because something new will happen. There'll be a change in technology, change in policy, change in government, international event will happen that you have to respond to. And what you want is the ability to adjust and respond in a balanced and measured way to whatever that shock to the system is. And there are shocks to the system, and there will continue to be shocks to the system. And I guess the last thing I'll say is that it's complicated. There are so many different interests and regimes. So like the agencies have a mission. They have to carry it out. We want them to carry out that mission effectively. At the same time, we're suspicious of the agencies. We don't want them to go too far. We want to know what the heck they're doing. At the same time, we know that we can't know everything they're doing. And then that's if you're looking at each agency has its own culture, its own history, its own mission, its own set of rules. Then you look at the federal government versus state and local governments. Well, that's a whole different story right there. Then you look at us as we compare to other countries around the world and their legal regimes and their legal frameworks. And we'll talk about the EU in a second, but the EU is itself extremely complicated. They have GDPR now, but they also have different legal frameworks in each country for national security activities. And they have a different international convention that applies in that space. So there's a lot of complexity, and the one thing I've learned, among the things I've learned, is there is just no magic bullet. There's no one-size-fits-all answer, and instead it's really your approach and your ability to stay true to the principles while being flexible with different circumstances.
So I like your gyroscope analogy, but to some extent, doesn't that imply that the other forces are all working toward the same end goal, if you will? In other words, we're here at a conference on cyber enablement. How do we get to a point where all jurisdictions? The panel this morning was all about how do these different jurisdictions approach things, and can we come up with a way? There were a couple of folks who said, let's all work on this together. Do we see that same thing happening when you take it from, when I say cyber, I think, obviously given my background, cybersecurity, but do we see that same sort of goal or mission, combined mission, that then leads to your gyroscope analogy? Because I don't see it as much on the privacy side. I see very divergent approaches at times.
So I think they're divergent approaches, but in my experience, the goal is still the same. So the approaches diverge based on circumstances, based on the history of different countries and their legal frameworks. You cannot have the identical thing work for all agencies in the federal government, just as you can't have them work for all countries. So I do think if you abstract it enough, of course there's a question of it no longer being useful if you abstract it too much, but I do think that at least the democracies all share the basic same goals, and it's just really a question of how do you get there.
Okay. Michel?
Well, I would start actually from the last point that Alex was making. I think we share values, and if I look at the EU and the US, it's true that we have a difference in the sense that in the Europe, privacy is a fundamental right. It is in our Charter of Fundamental Rights, which is, by the way, where the GDPR is coming from. However, if you look at the values we are implementing, they are the same. They are about democracy, rule of law, freedom of speech, etc., etc. So in a way, the differences are not so big. It's more the how you do it, which is really the difference. And of course, let me make a few points about the GDPR. The GDPR is providing us in Europe with the balance we wanted between privacy and security. And GDPR is working. 1 year after its implementation, I can say that some of the fears which were manifested at the time of the adoption have not materialized at all. On the contrary, it is beneficial to industry because what it does, it's actually simplifying the legislative framework. Before we had 28 different legislations, now we have one which is applicable throughout a single market of 500 million citizens. That makes a huge difference. And business is also reporting to us that the cost of data breaches is much less now that GDPR is in force. And I don't need to mention the benefits for the citizens, portability, the right to consent, the right to be forgotten, all these things which would have prevented Cambridge Analytica if at the time the GDPR was in force. So it's really beneficial. And we see that in the US, you have a discussion about whether introducing a legislation similar, not the same, but similar to GDPR. By the way, I personally welcome that California has decided to make this decision, and I think the law will be implemented in January 2020, if I'm not mistaken. And I think, in a way, you find the same problem as we had it before. We had 28 different national regimes, now one, and if you allow California to go on its own, I think you will have the same problem because you will have different legislations applying throughout the US. So in my view, there is a strong benefit to have one federal legislation on data protection, and I'm not even arguing for it to be exactly the same as we have in Europe. But I think one point we need to reflect on is the idea of global standards. Because as I said, we have the same values. And if I look at a number of countries across the world, Japan, Canada, EU, the US, these values are the same. And it would be good, indeed, to have one global standard for data protection, for privacy. That would, I think, avoid us a lot of difficult discussions with China as a commercial partner. And the other point I wanted to make is about, yes, privacy is good, not only for citizens, not only because it's a legislation in Europe which simplifies the life of business, but also because it helps with security. The fact that with this legislation you prevent non-authorized access and use of data is something which is good for security. But I think it's not enough. And what is going on now, what we are seeing online, hate speech, misinformation, propaganda, fake news, all of this is something which is deeply damaging. Deeply damaging for citizens, but also for businesses and for the industry. And there, I think we need, in my view, to complement GDPR, we need other measures. One, I think, is some decisions about what is allowed, what is creepy and what is not creepy. And I have to say that in Europe, it has started. For example, Germany, they have introduced a law on hate speech. The UK is also considering a legislation on hate speech, which I think would be useful. We ourselves in the European Commission, we have proposed some legislation on terrorism content, which is still being discussed. But I think we need at some point to set some limits. Because what is happening now is all of this is actually handled in a way which is on a case-by-case basis with a strong responsibility on the shoulders of the industry. And it does not always work. In my view, if I look at Facebook, it's a little bit like the sorcerer apprentice, you know. They allow something to happen, and then when it gets wrong, they try to correct it. And I'm not always convinced, and maybe you are also not convinced, that the solution proposed is the right one. So I think authorities should set some clear rules on what is allowed, not necessarily legislation. It can be a regulation or self-regulation by the industry in coordination with the authority. Finally, the point I wanted to make, it's also very important to allow law enforcement authorities to do their job. It's not because we have GDPR in Europe that we are saying that the role of the authorities, of the enforcement authorities, should be constrained. Not at all. We recognize it. For example, in Sri Lanka, you have noticed that they have decided to to block access to all social media immediately. And I think that's the right thing to do. In spite of the freedom of speech, clearly the social media were used actually to put more oil on the fire and to create more hate in this country, which is deeply divided. So that's basically where I come from, and I'll be happy to continue the discussion. By the way, I like also the gyroscope image, but for me it's a little bit more like a bicycle, because in order to keep the balance, you need to keep moving in order to adapt to your landscape and to the road. Thank you.
Very good. I could bring up a couple of different things, but I think, Joel, it's probably
Okay.
a natural progression from what was just mentioned over to you with Wickr.
I think it's a bicycle on top of a motorbike
On a tightrope.
on a tightrope
With a
over
bear.
a bunch of great white sharks. Okay, so my name is Joel Wallenstrom. I am the CEO of Wickr. Who knows what Wickr does? Okay, so it's it's a very secure and private communication product, but I'd say it's a data transfer layer where you can keep things mostly unobtainable. You know, there are no silver bullets, but there are better bullets, and we think we have a pretty good one. I come from a different world and background maybe in so much as when I say a security background, since 2000, I've worked for a company called At Stake, and then I started a company called ICCCE Partners, and ultimately what that meant was big companies, like the biggest companies in technology now, would hire us to try and break their products and get unauthorized access to data, usually is what that meant. Sometimes it meant that we could knock them down and make them non-functional. And we batted 1,000. There wasn't data that was not going to be accessible in what typically is an enterprise product or a consumer product. Mostly because things are built such that traffic can get in and out of systems. I mean, getting access to data is how things typically work. And so all we had to do is patiently understand how people were getting access to it, and we would figure out the business logic behind the successful attack. So when presented with something that's cryptographically certain or semi-mathematically provable that we're protecting things differently, I thought that was interesting because it took out some of the human element. It took out some of the server side, configuration. I'm going to keep all the data and try and protect it. Here's a place where you can say genuinely, I don't have the data. So it changes these things like GDPR, where we're trying to create rules where how do you access the data? It's a very different thing to have a binary approach to say, I'm not going to have it. This is not something we're going to do. Part of my business model is I will never have or be able to touch the data. It makes it difficult when you go, say, to Sand Hill Road to talk to VCs and say, I'm the one company that has no ability to monetize data. It's a very disruptive, different thing. Now, what I'm also going to say that I think is very difficult, and we'll get right back into GDPR, is that one of the things, there's business and there's consumers and there's government, but there's also, I think of business as corporate thought processes, but there's entrepreneurial issues here. And we can see this right now. Go outside and there are scooters laying all over the ground. And this is how it works. People don't create technologies to conform to the rules. They throw scooters in the streets and say, figure it out, right? And so to a certain extent, that's what Wickr was. It was very early days of the type of end-to-end encrypted processes that we do. People just said, let's go throw this in the marketplace and we'll let the world sort itself out. And this is sort of what's happening now. We're creating corporate products, giving people the ability to deal with compliance issues. Regulatory requirements are a real thing. Businesses don't sniff at those. So you have to take that really binary technology and change it. Like you're seeing scooters with locks on them now. And so that changes. But trying to create policies to stay in front of innovation has been a very difficult thing for us to do in this world. I don't mean that we shouldn't try to. I just mean that's a really hard thing. And so, that would be my Silicon Valley approach on this stuff.
So let me add on to the end of that, because I think it bears a little bit of emphasis. This is what I wanted to bring up when Michel was done, but I thought it made sense to have you do your comments. I want to come back to CCPA as an example of something that I think Joel is talking about, the types of things that put up roadblocks and innovation still has to happen. When you have something like CCPA, I mean, I remember when it first came out, I read it again, focused in and read it a third time. Does this really say what I think it says? Which is an entrepreneur has to provide the same service to someone even if they decide not to give their personal data. Is that great for privacy? Sure. But what does that do with respect to these services? So I was talking earlier about the free services. They're not free. The currency is in the personal data. So coming back to what Michel was saying and what Alex was saying in terms of striking that balance, how do we, or even is there a way, maybe as the fun, actually I'm jumping the gun here that gets into our actual first question for the panel, but how do we get to a point where we don't stifle one of these major stakeholders? If you make it too secure, you stifle law enforcement. If you make it too privacy-oriented, you stifle innovation. So how do we strike that balance? To some extent, maybe it is, a bit lofty, and we need to come at it in careful ways. But I kind of wanted to get that out there, as we have an example today of the type of thing that we're talking about that, I mean, my personal opinion only, not Cooley, not any of my clients, all the usual disclaimers, I personally think it's going to become a problem if that type of approach takes hold. GDPR, I agree, has done some good things for all of the different major stakeholders. But I think if we take it too far, we run into situations where, in particular, here at a cyber enablement conference, you may wind up running into problems. With that,
Yeah, go.
Joel or Eija, go ahead.
Thanks. Well, whoops. It doesn't want to turn on, so, okay. Thank you. Well, good afternoon, everyone. So I'm an attorney, as I think you mentioned in the beginning, working in the really, really dark side, so to say. And before joining the firm, I was working for the Finnish Data Protection Authority. So that's actually where I started my career almost 20 years ago. And on a daily work, I advise clients on how to handle GDPR requirements in a right way to balance individuals' rights with corporations or governmental parties' interest to collect and process data. So how to handle that and how to do business still in compliance with GDPR. And I wanted to continue where my European colleague here started with the human rights approach. And even if we share the values in this field as well, we do have a very different approach on privacy. What does it mean, and how we as an individuals see and experience that. And I think it's important to understand where the European approach comes when we go far away in a history, and what has sort of formulated the Europeans' way of thinking of privacy and the importance of today's rules and requirements. And with the history, we need to go to the Second World War and to Germany. And at that time, there were no rules on who can collect data, for what purposes, and what amount, and all that. And we all know what happened in Germany during the Second World War by Nazis and all that. And after the war, it was kind of a common understanding in Europe that there has to be rules on this area. It can't be that somebody, organization, could collect any data for whatever purposes, not being transparent to the individuals and not having any tools kind of interfere that. So putting that into a perspective, maybe that explains a little bit where, if I can call Europe as a sort of a one region, so to say, is thinking these issues. And with the GDPR, as Michel said, the point really is not black and white, so to say, that individuals would have all the powers in the world to control their data or other way around. It's really balancing that the individuals do have a right to know even if they cannot every time decide or choose whether somebody can collect and process their data. So it's really a balancing and being aware of what's happening, not really giving a control or total control for one party only. And yeah, maybe that's as a starter a little bit of my background and the approach for the topic.
All right, very good. So we're going to turn now to Q&A. As I said, I like making things interactive. So if anyone has a question, either here or in the overflow room, want to come over to the microphone, we'll take questions. But if not, and while you're queuing up, so to speak, I'll start with the one that I kind of alluded to earlier. I think, as you can tell, none of us are up here out at the extremes. Nobody's here saying we don't need security or we don't need privacy. But I think one of the things that we are seeing is everyone agrees security is important, obviously, from a government, from a commercial, from an individual consumer perspective. Likewise, privacy. So you've got both of those as important, and the question is, you know, for lack of a better way of saying it, is each of those the enemy of the other? We said, I used the word bipolar in the prep session, and Alex brought that up. You know, is there a space in the middle where we can meet, and what are some of the tangible things that we could do to get there? Can they coexist in a reasonable balance? So I'll toss that one out to the panel, and again, encourage people to disagree and argue and make it fun.
I don't think that they're inapposite, and you can only have one without the other. I think it's important, though, that you proactively think about it and process it. And as a personal example, I used to keep my location services off, not because I was going anywhere particularly interesting, but I thought it was nobody's business. But then I realized with it on, I can get my nearest Starbucks, and I can order the coffee, and it's waiting for me, and that's very efficient and convenient. And so I've chosen to give up that amount of information so that I can get my coffee faster. And that's a value to me, and I understand the benefit, and it's a conscious choice. And I think that if we consider privacy more in the ideas of what do we most care about, what are we willing to give up versus not, and make conscious choices with transparency and disclosure, then we can market it, we can monetize it, people understand it. But the question is really, do people understand it? And people have gone ahead and given up significant amounts of information and data without thinking of the repercussions of it. And companies have collected it. Some companies aren't even aware of how much data is being collected or where that data is going after they take it from their customers. It's going to third parties and elsewhere. And I think we just have to collectively as a society get a lot smarter on what we're doing and make sure that we are sufficiently transparent. Like Michel, you mentioned hate speech and fake news and propaganda being a problem, but the concern is if you go too hard on that, are you then squashing free speech and privacy because you're working harder on attribution and figure out who's making those statements, right? So there's all different balances and interests, but I don't think you have to have either one or the other. Okay. But we have to come intelligently based on our norms and comfort levels, how do we get to a comfortable solution? And it starts with transparency.
So I won't put you on the spot, so to speak, but let's just talk about our profession. For those of us in the legal profession, we have clients who want us to write privacy policies that are full disclosure. But how many of you read privacy policies when I asked earlier? All right, okay, now we got one person raising his hand. Okay, so I think it again comes back to, maybe this is the wrong room to be raising this in terms of, you know, do you understand? Because all y'all, I'm sure, understand how this stuff works. It's the rest of the population, or a lot of the rest of the population, that I don't think understands what's fake news, what's a good service versus what's a bad service. How do I protect my personal data? So I think there's a tension here, again, back to, I don't want to say e-commerce, but essentially providing services in a way that the company's protected. They want to give disclosure, but if the disclosure is written in a way that folks don't understand what's happening, you know,
Well, if I could just jump
Sure,
in. So let me
please.
echo what Judy said about, there's a couple different things. So one is, and to get at your question, I think we're striking those balances all the time, right? So that
Individually.
well, that's true, but I was just thinking as a society. So in industry and certainly in the government and what we're doing, there are constant choices that are being made that are attempts to strike the balance, because people recognize that both of those values are important. Like, security is important, so is privacy. How do you strike that balance given the laws that apply in this situation, given, consumer expectations, public expectations, given a whole range of different factors. So in my experience in government, I've never seen people say, you know what, the heck with it, we're going all the way over here and forget about everything else and let's not even bother with any analysis. There's a lot of care being taken. It may not seem that way on the outside, which is where I get to this, to where Judy ended up, which is it starts with transparency. And I mentioned earlier that one of the changes for my position is that we added transparency to it. So you can have all the rules and all the oversight, you can strike as careful a balance as you want, but if the public doesn't understand what you're doing, you are going to be in a very difficult position to try to get yourself out of a trust deficit when they find things out that are inaccurate or or lack the appropriate context. So getting to and so we've launched a whole initiative in the intelligence community to figure out how can we be more transparent while still protecting classified information. It's extremely difficult, but it's doable. We've done different things on social media and with websites and trying to put out a lot of information, try and find different ways to put it out. Here's where I get to the privacy policy thing. So you could just put something out, which is what we did in the early days, highly legalistic, highly technical document with a lot of redactions and no explanation. And we worked very hard to get that document out, and then we said, aha, we did it. So not many people read those documents, and in order to understand them, you had to be an expert. You had to already know what was going on before you could even understand the document. So that really wasn't accomplishing a purpose other than us being able to say, yeah, we put a document out. So now we're spending a lot more time in how we prepare the documents which we expect to become public. Even with classified information, finding ways to move the classified information into footnotes or into appendices or something else, and write the core document, even a legalistic oversight document, in a way that the public can more readily understand. And so I think companies are starting to do that with privacy policies as well, and I know that there's been a lot of talk about how to do context-specific choices so that if you're going to give up your location information, you know at the time. That's the most effective, right? You're given a yes-no. But those are difficult, and you guys know more about how to design those than I do. I will say this, that in the government's case, so if I'm ordering something from Amazon and it's telling me what my preferences are or what, recommending things for the future, I see the benefit of them having access to my purchase history and everything else. Like, this is great. I can see that benefit right off the bat. Mm-hmm. If I hear about a government collection program, I don't see the benefit, and instead what is the natural response with people is suspicion and fear. Like, oh, they're tracking my movements. Oh, wait a minute, I don't want them tracking my movements. For perfectly legitimate, I don't want people tracking my movements either. So the first reaction is fear and suspicion, whereas with the companies, the value proposition of giving up your personal information is much more apparent. And so one of the things that transparency can do is just better inform people, not only in the private sector, but also with respect to the government's actions. Like, what is going on here? Why would they want access to this kind of information? And how do I know that they're not going to take it and use it in an abusive way? So that's been kind of what we're trying to get at with the transparency work. Obviously, a lot more work to do.
Do folks feel that, maybe a show of hands, how many folks feel that the consuming public, no matter what the jurisdiction, understands the benefit of turning over their personal data? Or, I'm sorry, perceives that they understand the benefit of turning it over? Okay? Because I think it really is a perception issue. I think part of where we are today, and I think we're seeing that sort of across, well, maybe I'm going a little too far, but I think we all see it in different things that we do, is I've always been fascinated by the fact that here in the United States, consumers tend to have a strong distrust of the government, which is what our country is based on. And I think there's a place for that, to not trust your government fully. But I think there's also an approach where you put too much trust in the commercial sector and what they're going to do with your data. And so I again go back to, how do we get to a point? Transparency, I think, on the government side is great. You've got citizens now having better trust, understanding better what the government is doing, but how do we get there from a commercial sector? So,
But frankly, in recent discussions, I've been frankly shocked by the way many people perceive services like Facebook or Google. For many people, students even, they think these services are free. They believe these services are free. They don't realize that they themselves are the product. And so this kind of misperception
currency,
is
yeah.
still very widespread. That's really a big issue, a big misunderstanding. And I would say all the legal notices, frankly, okay, that's fine. It's not very useful. I remember just after the 25th of May 2018, which is the date of entry into force of the GDPR, I received a lot of notices from various companies. I read some of these notices. I could not really understand what they were meaning. Even in my own native language, French, they were sometimes even worse than in English, I can tell you. So I don't think that's the issue. People want some safeguards that they understand. When you explain to people the right to consent, the right to be forgotten, portability, they understand what it means. So you need these kind of legal safeguards to be in place for people to understand that they are secure, relatively secure. And for me, this is why GDPR is a step forward. And I hope that, again, there can be some international discussion about setting a global standard on data protection. Now, it seems to me that this kind of privacy, this kind of data protection is a step towards security. Less access to data or less non-authorized access to data, that's important, but it's not enough. I mean, let's all remember we had Cambridge Analytica, we had foreign interventions in the US elections, but also European elections. Recently, we had these New Zealand attacks, we had Sri Lanka. In all these cases, social media played a role which was extremely dangerous. You remember that in the New Zealand attack, actually it took 17 minutes for Facebook to stop the diffusion of the video. And hundreds of thousands of copies were made at the time. So for me, honestly, is it acceptable? I don't think so. We need something, I'm not saying legislation, but we need something, a tool, an instrument, whereby this kind of incident can be stopped instantly. Because it's a question of injuries, of death, of financial losses, which are huge. And this is something we would not accept in the offline world. So we need something, and I don't know what it is, but we need the instrument to try to stop this kind of incidents.
So I come back to something I think Alex talked about, the trust deficit that we run into. And I think with the Facebook example and other companies out there, people have put their trust in this property and all of a sudden find out, and then they read the privacy policy, and the privacy policy, which we've helped write in many cases, not that one, but just generally, it'll say something that says, and we can share it with our affiliates. Okay, I read that. I'm a consuming public. Okay, fine. I want to get at the service. What I don't realize is that sharing it with the affiliates of the company is now being sold. So I agree that the controls and wanting the controls in place so that we regain the trust is important. My fear is that when we start going too far in certain directions, we run up against the First Amendment type issues. When you talk about controls over speech and being able to cut things down, and I actually look at this as an imperfect system. We will never get to perfect. It's like one of my constitutional law professors wrote a book about mathematical concepts and the Constitution. And folks know what an asymptote is. It's a curve that approaches but never actually touches an axis. You never get to that point. It goes on to infinity. And the idea is we may get closer and closer to a system that essentially meets the requirements of most jurisdictions and most people and most values, but will never hit the sweet spot, as someone said. And I think we have to recognize that there will be imperfection, there will be mistakes. And I think the question, maybe toss it out to the group here, where are those mistakes okay? Can we have a system that instantly takes content off to help save lives and protect people? Great goal, but what happens when you take something off that shouldn't have been taken off? And then you have to go back and put it back on, or put it, put it back up on the property. And there's any number of other situations where you're going to have false positives. And I guess the question becomes, what can we live with? Joel?
Well, so I mean, that's the flip side of my issue at Wickr, I guess, to a certain extent, because we provide, we don't provide access. So people ask us, when is it okay to put a backdoor into your product? And the answer is, for us, never. Like, that's just not what we do. We want to make transparent promises to the people who are using our product. If we're at a corporation and they've decided they want to buy a version with their own backdoor, they can do that for their employees. That's a different sort of thing. But when you make a very specific binary promise and you're transparent about it, I think everyone operates within those rules. We're not a social media. I mean, we're not going to create that sort of groundswell of people being able to do the things that you're concerned about. So first of all, in that question, I don't think there is a perfect answer for any of this. I think reasonable people need to be involved in the process, and you need to create policies, and they need to be transparent, and everybody needs to understand what's happening. But beyond defining that predictable outcome, it's going to be very hard, because once you do something that is akin to a backdoor, and I would say, not to pick on AT&T, but if anyone here was around their carrier IQ issue or RSA's issue around their, the trust deficit, to use your point, Alex, it becomes very deep and it becomes very intractable. And so I love that we're all going towards transparency, but I don't think that means then you create flexibility in when you're going to be transparent and how you're going to execute against those promises. You have to be true to your promise.
Okay.
Yeah, I was thinking about this conflict between different rights. I mean, if we talk about right to privacy, we mentioned that it's a fundamental right and it's human right, and it doesn't mean that it could never be violated. I mean, of course, there will be situations when even such a strong right need to be violated legally, so to say, or there needs to be a legal grounds. And I think there is, at least some case law or argumentation around that topic is, some of you might remember a few years back there was this European Court of Justice gave a decision, this Costella decision, which was about a Spanish lawyer who wanted to his data to be removed from search engines, like these search results. And as an outcome, it was litigated quite long time, but eventually Costella was entitled to have old data about him removed from those search results. And after that, it created a lot of these right to be forgotten requests in different European countries. And oftentimes in those cases, if someone writes something about an individual, the argumentation is that, well, I have a freedom of speech. I can write whatever I want. And then the other individual says, well, I have a right to privacy, so you cannot write anything about me if I don't want, if it's too private. So how do we solve this issue? Because you have a freedom of speech and I have a right to privacy. And then eventually you need to balance on a case-by-case basis what overweights the other in that specific scenario. It's not possible to give a rule that, these details apply in every case and right, whether it's either or. But it's a case-by-case analysis, and I think if you ever have a chance to read on those cases, it's really interesting argumentation when they balance those strong individuals' rights against one another and then come to a solution in every or in each specific cases.
So in some ways, maybe taking a more reactive approach. I know, Michel, you mentioned not necessarily legislation, but maybe regulation or self-regulation in advance. I think Joel kind of pointed out there can be concerns about that, and we've seen the same thing here in the U.S. with a lot of our free speech law. It wasn't, put in stone or put into a reg or put into a law. It was developed over the years as these cases came up that were tough calls, and in some cases it goes up to the Supreme Court because it's such a close call, and that's how the law develops.
So this is hopefully a helpful perspective on this. So I think it might be a little different. I do think privacy and security are often enemies. And I'm looking at this from my old client base. If, you know, on an org chart, they often report to them in different places. They're competing for budgets. Building a secure product has very little to do with anything to do with user privacy. It has to do with, can this be abused in any certain way? These are computer scientists or engineers who are building things, and the privacy people are lawyers and policymakers who are writing policies. And they often don't mix, and they also often are competing for resources and time and energy. I've been involved in, I don't know, 50 CISO searches, and they always ask, can he or she speak to the board? This has nothing to do with, the philosophy behind GDPR. It's, can we underwrite it? What are the financial consequences? They need to talk to them as risk officers. They don't want to hear about input filtering on their web app. That's not anything that a board understands, and that's security. And they really don't understand anything about, the board doesn't understand GDPR. They just understand there might be a liability out there, and how do we hedge that bet? That's what is happening now in the organizations that are building these platforms upon which all this data is living, and then we have these philosophical discussions about what to do, which I think is important because, to your point, that one case was the breadcrumb that led to GDPR. And people do now care about it, but not in the sense of privacy. Board members care about it, but it's more, what is this going to do to us? And if I can write this off and continue to just go and make our revenue spike, a board member would say that he or she would probably approve that, I think.
But that's a big part of the problem, really, is
Yeah.
because traditionally the security folks and the privacy folks have been siloed, and the business people aren't talking to either.
Yeah.
And so much of when we talk about cybersecurity and privacy and where and how they intersect within an organization or within government or within the laws that we're trying to figure out to finesse all this, it's so much an organizational communication issue.
Yeah.
You don't have the right people asking the right questions and in the same room talking to each other. And it shouldn't be a philosophical discussion. It should be a very practical discussion. Let's take the cybersecurity part. What information do we care most about? Maybe it's our communication, so we should consider having encrypted communications like your company offers. Maybe it's our client data, because if that gets out, that would be really bad for our reputation and our business model and whatever else. Or maybe it's business continuity, but how do we consider and prioritize the things that we care most about? But you need the privacy people at the table as well to talk about what even does the organization have that needs to be collected, and how much of that can be better not kept. You don't necessarily need your employee health data if it can be sent someplace else that has more security than your organization may have, for example.
Yeah, I think a really funny thing on security too, even within security it's split. So the best product security people want to build products that can be made safe, but the threat intel guys want as much telemetry on the bad guys as they can potentially get. And so it's schizophrenic, really, even a very bottom level of a big organization. There are, and then I know one of the biggest social network companies that really got less. I mean, they were very not dragnetting their employees because they were so good at investigations. So they wanted to give privacy to their employees, and yet their users, they were gathering everything for monetization. So it's just different all across the landscape. And I think that that's there are very few people that define security the same way or privacy the same way.
But
really
I do
across the
think,
board.
and we have a question back, but I'll give a little bit of a foreshadowing here of how we're going to kind of wrap up the discussion. I think there are tangible things that are happening that make a lot of these discussions not philosophical, that they are more practical. I've been in three projects that involve security by design and privacy by design. And I think one of the things that came out of GDPR that companies are latching onto is the notion that you do need all of these folks in the same room. Judy was mentioning you need the privacy folks, the security folks, the policy folks, the HR folks, the C-suite, all in the same room. I've been on 3 projects like that. Not for small, like super innovative companies. Well, one was, but these are bigger companies that are really starting to get this, and they get it at the board level. You can talk to a board about security by design or privacy by design, which is essentially just building in this stuff further ahead, further toward the front of the process, and not making it sort of a bolt-on at the end. All right, I'll stop there and, yeah, I'll stop there and take the question back.
Sure. Hi, good afternoon. My name's Sarah Robinson. I've actually been sitting at this confluence of cybersecurity and data privacy for about 4.5, 5 years at Deloitte & Touche. And so I get to be a part of many organizations that are trying to navigate all of this all the time. So, and often I end up chatting with clients about, look, you know, firefighters and police officers are both first responders, but they do very, very different things. And I may or may not want them to do very different things when they arrive on the scene of some sort of accident. And so really what my question is more about sort of your crystal balls as you look at influencing the world stage, trans-state actors, not just corporations, but obviously nation states, et cetera. And what is it that you see as the best way forward to prevent, really prevent parties from using these regulations as a method for an end run, really? In my experience, it takes pretty deep technical expertise and insider knowledge that is held very, very close to the chest by very few people and organizations that are trying to navigate all of this. And so transparency is a really lovely word, and 4% of global revenue is sometimes a very meaningful number. But it is thorny, and it's thorny for a reason. And I actually find a lot of clients, even as genuine as they might be, deeply struggling with any amount of, you know, people want to do what they want to do, right? So I'm just kind of interested in, is it carrot and stick? Is it more enforcement? I mean, what are you thinking about moving forward? Thank you.
I mean, in Europe, there is a general saying that the legislation we have is outpaced by the technology by like 10 or 15 years. That's basically, you hear everywhere lawyers saying that the courts are operating with laws which are outdated since 10 or 15 years. And actually, it keeps even moving, because if you look at the impact of artificial intelligence, recently I was part of a discussion on whether GDPR was actually already obsolete because some of the aspects of the deep learning on data sets. And so that's something we have to live with. And I don't think we need, I think I agree with what Joel said about you need to avoid a situation where policies is ahead of innovation, because generally that produces a bad result. But you also have to avoid the situation where laws are really far behind what's going on with technology. So my point is basically GDPR is here, it's helping us. We also have security legislation. As I said, we have made recently a proposal on terrorist content. That's very useful, but we should keep an eye on our legislation. That's basically the role of the authorities. First of all, not to legislate as a sort of knee-jerk reaction. We need actually to be attentive to the point where we have a stable environment before we decide to legislate. And I would say always prefer self-regulation solutions. The industry can find solutions on its own with the help and the cooperation of the law enforcement authorities. And these solutions can be implemented swiftly. And it's only in the case where they are not working that we should come out with some legislation. And maybe